Americans are more divided today than they've ever been since the Civil War. That division gets reflected in tie votes. We have to anticipate a tie vote in the United States Senate for confirmation of President Trump's nomination to the Supreme Court. We have to anticipate a possible tie vote in the Electoral College among the voters, essentially a tie the way it was a tie in 2000. And we have to anticipate the possibility of a tie vote in the United States Supreme Court, especially if there are only 8 justices. How do we deal with these divisions? How do we deal with these ties? We're going to analyze these issues the way law students do at Harvard Law School. You will hear my analysis and my answer to viewers' questions today on The Dershow. Americans are more divided now than they've ever been since the Civil War. And it's reflected by our own institutions. Let me give you 3 nightmare scenarios that reflect the division, not only among our people, but among our institutions. It is certainly possible that we will get a tie vote as to whether to confirm President Trump's nomination to the Supreme Court. 50 senators voting yes, 50 senators voting no, and it will require the vice president to break the tie, and I'm going to talk in a moment about whether that would be proper in the case of a Supreme Court justice. So that's scenario number 1, a tie vote in the United States Senate. Scenario number 2 is we get a tie vote in the election on November 3rd. We had a tie vote essentially in the 2000 election, and that tie had to be broken by the United States Supreme Court. When I say a tie vote, I don't mean literally the same number of people, but approximately the same number of people. But even more important, we get a very, very close vote in the Electoral College, and it all turns on one state, maybe Florida, maybe Michigan, maybe Pennsylvania. And the vote there is very, very, very close. So that's tie number 2, a tie in the election. And then the case goes up to the United States Supreme Court, which, at least under the nightmare scenario, doesn't have a 9th justice because President Trump's nominee either has not yet been confirmed or has been voted down. There are so many possibilities, but the likelihood, at least the possibility, is we may have 8 justices deciding the election. And so that gets decided on a 4-4 vote. So we have a tie in the Senate, a tie essentially in the Electoral College and in the voters, and a tie in the United States Supreme Court. I have to tell you, I've looked through the Constitution very, very carefully, and the Constitution just doesn't speak to what happens when the nation is so terribly divided. Yeah, it does provide that the vice president gets to cast the deciding vote on matters where there's a split, where there's a 50-50 tie in the Senate. But the question arises, and I'm sure it's going to be raised, does it apply to nominees to the Supreme Court of the United States? We've never had it before. We've never had a justice confirmed for a lifetime appointment by a divided vote of the United States Supreme Court. After all, the Constitution says the president shall nominate and by and with the consent of the Senate appoint justices of the Supreme Court. And so the question arises, is the Senate's function in advising and consenting different from the legislative function? We know that the vice president can cast the deciding vote if you have an up and down vote on a law and it's 50-50, the vice president gets to cast that deciding vote, making it 51-50. Is the same thing true for a divided vote advising and consenting to the nomination of a Supreme Court justice? Is the consent function of the Supreme Court nominee by the Senate, is that consent function of the Senate more personal? Does it really require the consent of more than a majority or a majority of sitting senators rather than this kind of constitutional majority which is 50 senators on one side, 50 senators on the other side, and then the vice president, a member of the executive branch, casting the deciding vote. Some will argue that it gives the president too much power in the appointment of a Supreme Court justice. After all, it then gives him, the president, the power to nominate, but also gives the president the power to consent to his own nomination, because obviously the vice president's going to do the president's bidding. So the president, under this scenario, gets to nominate. He also gets to consent to his own nomination. Is that what the framers really had in mind? Would certain senators perhaps say, look, I'm not sure, I'm on the fence, maybe I'm for the nominee, maybe I'm against the nominee, but I really don't want to appoint somebody to a lifetime job on the basis of a 50-50 vote of the Senate. I think we need more than that. Remember, until recently, you needed a supermajority. We had the filibuster rules, the nuclear option, all of that. But that changed in the past couple of years, by the way, as a result of actions initially by the Democrats and then by the Republicans, eliminating the filibuster for judicial appointments, eliminating the supermajority for Supreme Court appointments. So until recently, the vice president couldn't cast the deciding vote on judicial nominations, certainly not on Supreme Court nominations, because you needed more than 50 votes. If you got a 50-50 tie, the vice president didn't get to break it because the vice president's vote would be meaningless if you needed 60 in order to get the nomination confirmed and through. So this is a question of first impression. And I know there are people thinking about it right now. I'd be interested in knowing what your views on that are. Should a justice be confirmed for a lifetime appointment based on a 50-50 vote? We don't know who the president's going to nominate, but among the people on his short list is Judge Barrett, who is, I think, 46 years old. And according to demographics, she can certainly be expected to live until 86. That's how long Ruth Bader Ginsburg lived approximately. And that would mean 40 years on the bench based on a 50-50 divided vote. Will it lead some senators to scratch their heads and say, maybe this isn't what the framers intended? There's no clear answer to the question. The Constitution doesn't speak to it, but it is a reflection of the incredible division that we experience today among Americans and in our institutions. It would be symbolic and ironic if the vote came down to 50-50, because it would probably reflect basically the division among the American public. So that's one issue, a divided Senate. Then we get to a divided electorate. It's going to possibly be a close election. Maybe not. Nobody knows. The polls show that it won't be a close election, but so did the 2016 poll show that it wouldn't be a close election. So polls aren't definitive. And what if we get a close election? We haven't had a situation in many, many, many decades where an election is thrown into the House of Representatives, but that could happen. Under the Constitution, if no candidate gets a clear majority of the electors, the case gets decided by the House of Representatives, but not by the votes of each individual member of Congress. It gets decided by state delegations. Each state gets to cast one vote. If any of you saw Hamilton, the play, you know how long that could take. Jefferson's election against Burr, resulting ultimately in the 12th Amendment being passed, which now makes that impossible for a president and a vice president to be competing with each other for who gets to be the president. But we could conceivably get a situation where the election is taken to the House of Representatives. More likely, we would get an election which would end up in the United States Supreme Court, as the 2000 election did. Now, we don't know how it would get to the Supreme Court. In Bush versus Gore, I was one of the lawyers. I represented the voters of Palm Beach County. Remember the infamous butterfly ballot, where Jewish voters who hated Pat Buchanan because he was so virulently anti-Israel and many thought anti-Semitic, ended up voting for Buchanan because the butterfly ballot was so confusing that if you wanted to cast a vote for the Jewish vice presidential candidate, Joe Lieberman, it was on the same line as the vote for Pat Buchanan, and at least hundreds, maybe even thousands of people erroneously voted for Buchanan instead of voting for the Gore-Lieberman ticket, which may have turned Florida over to George W. Bush and ultimately gave him the presidency. And so the case lingered through the state courts and the federal courts, and eventually didn't get to the Supreme Court until very, very late in the process. By that time, it gave the justices an opportunity to say, look, we're in a crisis mode. We have to render a decision for this day and this time only, a decision which many scholars, including me, railed against as an improper invocation of the Equal Protection Clause in an area that it was never before applied, certainly by the justices who applied it. So we may get a situation like that, or we may get an attempt to bring the case to the Supreme Court immediately. The Supreme Court does have original jurisdiction in certain cases. And what happens if a case comes to the Supreme Court on original jurisdiction? There's no lower court opinion. And then the Supreme Court decides to vote 4-4. Usually the rule is if the vote is 4-4, the lower court decision is affirmed. But what if there is no lower court decision? Then I guess the rule would be that the decision of the voting commissioners that was being appealed would remain in effect. In other words, the Supreme Court's 4-4 decision would be a nullity. Do I think that's likely to happen? Don't know. Chief Justice John Roberts is a master at trying to protect the integrity, neutrality, objectivity, non-political nature of the Supreme Court. And he would try very hard to make sure that the vote was not 4-4, or if there were a new justice confirmed, that the vote was not 5-4 along strictly partisan lines, the way Bush versus Gore was. Look, these are the scenarios. We have to be prepared. We can't just wait until the last minute. We were unprepared in 2000 for Bush versus Gore. Right now, both campaigns are gearing up for legal fights. There may also be street fights. We live at a time when people are willing to take their arguments to the street. Michelle Goldberg, an op-ed writer for the New York Times, urged people to go to the streets. I don't know what she meant. Lawful protests, that's one thing. Illegal, violent protests, that's quite another. She wasn't as clear as she could be about the nature of going to the streets. But we have to prepare for every eventuality. We have to prepare for a tie vote in the Senate, essentially a tie vote in the Electoral College, a tie vote in the Supreme Court, street protests, maybe violence. We live in dangerous times. We live, to quote the novelist, in the best of times and the most dangerous of times. And preparation is absolutely essential. On the Dershow, you're going to hear me over the next weeks analyze and evaluate all the potential issues that we face in the Supreme Court, in the Senate, in the election, mail-in ballots. This is a time for thoughtful dialogue and conversation about these issues. We live in an age of division. We live in an age of ties. We live in an age where we need a process for breaking the ties. We live in an age where we need a process that's not only legitimate, but is apparently legitimate, gives the appearance of legitimacy. Because justice must not only be done, it must be seen to be done. So I welcome your input. We're going to be adding now to the Dershow questions from people who are viewing. A lot of you are viewing it. Thank you. I appreciate it very much. Tell your friends. But ask questions, short questions, and I promise I'll answer everyone. No question is too hard. No question is too embarrassing. No question is something I'm going to duck. I'm going to answer your questions. And so right now, I think a lot of the questions that I'm getting by email and telephone calls, or what happens in case of a tie in the Supreme Court, a tie in the Senate, a tie in the election. That's what we have to anticipate. That's what we have to prepare for. And frankly, that's what we have to worry about. Now it's time for viewer questions, comments, and criticisms. We begin with a comment from Dr. Deborah Bird in Florida.
Good morning, Mr. Dershowitz. This is Dr. Deborah Burns. I'm an internist from Sarasota, Florida, and I just listened to your podcast, Should President Trump Appoint RPG's Replacement? I thought it was very enlightening and informative, and I agree that the people should vote. And my comment is the people have voted. In 2016, we voted President Trump into office, and it's his responsibility to attend to the needs of the people and his responsibility to attend to his duties of his office until January 19th of 2021. If I'm an internist, which I am, and I'm in the ICU and it's 2 hours before the end of my shift, I don't stop working because it's before the end of my shift. I work up to the very minute and, in fact, probably over. So I don't understand why everybody is expecting President Trump not to do what we elected him to do. That is my comment. Thank you.
Dr. Bird, a great comment. And from a point of view of the Constitution, you're, of course, 100% right. The president could appoint 9 Supreme Court justices at 11:45 in the morning of January 20th. In fact, John Adams did almost just that. It was called the Midnight Judges. He appointed a whole slew of judges just as he was about to leave office, and Thomas Jefferson was furious. And it, of course, led to very important cases such as Marbury versus Madison. So the Constitution is very much on your side. The question is, what should the Senate do? The Senate has the obligation to advise and consent. And what if you're a senator who says, gee, I listened to when President Obama made an appointment of Merrick Garland, and in those days, all my Senate colleagues said, no, it's too late in the process. It was 8 months before the process. If they were right then, why is the rule different today? Shouldn't we apply the same standards without regard to which foot the shoe is on? Does it pass the shoe on the other foot test to have Republicans defeat the nomination made by President Obama of Merrick Garland? That nomination would have been supported by you, Dr. Bird, according to your analysis. But now switching theories when it comes to a president from your own party. So under your principles, Dr. Bird, both Garland and whoever the president nominates were properly nominated and should be confirmed. But under principles stated by some of the senators, including the majority leader, maybe you apply the same standards to President Trump as you did to President Obama. I would be interested to know what your views on that are, whether hypocrisy or changing views is enough to change votes, or whether everybody understands that we live in a world where decisions are made based on partisan considerations. But thank you so much for your excellent comment. The next question is from Preston. Hey, Preston, what do you have to say?
Hello, my question is, should Trump nominate Merrick Garland for RBG's replacement? By the way, the Dershow makes me feel I should have taken your course when I was across the river in 76 and 77. My name is Preston Ford. Take care. Bye now.
Hey, Preston, I wish you had taken my course. You sound like a brilliant man. Look, wouldn't it be wonderful? Wouldn't it show the greatest bipartisanship if President Trump were to nominate Merrick Garland? It would be terrific. It's not going to happen. Merrick Garland actually could have been nominated by a Republican. I know his writings. He's a down-the-middle person. He's conservative by nature. He is a Democrat by background. He would have been a great Supreme Court justice. Ain't going to happen, not in the partisan world in which we live, but thanks for your great insights. Our next question is from Matt. Let's hear from you.
Hi, this is Matt Becker from Baltimore, Maryland. I was just wondering your thoughts on an original intent judge or any of the nominees subscribe to that, and if that would be a good addition to the court. Thank you.
Well, thanks for your great question. I think every justice of the Supreme Court is an original intent justice. Everybody looks to the framers. Every justice I know has read the debates over the constitutional conventions, the debates over the ratification. And when you have an ambiguous phrase in the Constitution, you always look to original intent. The question is how much weight you give it. Give you an example. I have no doubt that the framers of the 14th Amendment, equal protection, did not have in mind integrated schools where African American children and white children went to school together. This was 1860s. Nobody imagined white and black kids going to school together. But the phrase equal protection of the law is an open-ended phrase and permitted in 1954 for a unanimous Supreme Court to vote that segregated schools were in violation of the Equal Protection Clause and unconstitutional. So the question is not, do you believe in the original intent? Of course you do. The question is how much weight you give it and how much weight you give it in particular areas. For example, there are parts of the Constitution that are dead. You have to be 35 to be president, not 34. You can't change that, no matter what the intent was. Let's assume you find original intent that shows that we wanted mature people. So if you have a 34-year-old who's mature, not good enough. You have to be 35. But equal protection, due process, cruel and unusual punishment, those are open-ended phrases that require interpretation. And there the question is, how much weight do you give original intention, original understanding? How much weight do you give contemporary needs and what kind of a country we are? The court is divided along those lines, and I think we need a diversity of justices representing a diversity of interpretive points of view. Thanks so much for your question. Hey, Mike from Oklahoma City, you're next.
Yo, this is Mike from Oklahoma City. I was just calling to ask if you would support the BDS movement on campus because they getting their free speech shut down left and right, bro. And no one's sticking up for their First Amendment. So would you support boycott, divest, sanction movement on Israel? Thanks, bro. Please answer the question.
I will answer that question. It's a great question. For me, the BDS movement would be the same as a movement that said, don't rent your apartments to black people. Don't rent your apartments to gay people. Boycott black people, boycott gay people. What's the difference between saying boycott black people, boycott gay people, and boycott Jewish people in Israel? So the movement itself, BDS, is obnoxious, illegal, because it advocates discrimination. And I would prohibit actually discriminating, the act of discriminating against Jews or Israelis based on national origin, based on religion. But I support the right to advocate. I support the right to advocate BDS, just as I would support the right of a racist to come on campus and advocate not renting to black people, not renting to gay people. You can advocate it, you just can't practice it. If you refuse to rent to a gay person or a black person, then you violated the law. If you refuse to do business with Israel or with Jews, remember BDS applies only to Jews who live in Israel, not to Muslims or Arabs who live in Israel. If you practice discrimination, you're engaging in illegality. But you can advocate it. That's covered by the First Amendment. So yes, I defend the right of people to advocate bigoted, racist actions such as BDS or refusing to rent to people of color or to people of a different sexual orientation. Hey, Richard from Louisville, what's your question?
Hey, Alan. I'm wondering whether you have any thoughts on sanctuary cities. Do you think that those laws are constitutional? I always thought that the president can override the states whenever he or she wants to. All right. Great to listen to the show.
Well, thanks. You're both right and wrong. The president can't override state laws if state laws are legitimate. The president doesn't have that authority. But the Supremacy Clause of the Constitution does provide that federal law is supreme over state law or city laws. And so I believe that sanctuary cities are unconstitutional. They're acts of civil disobedience. People might argue they're morally correct, but a city cannot make the decision to refuse to implement federal law. If there are federal laws and they're valid federal laws, cities and states must enforce them. Sandy from Ohio, what's on your mind?
Hi, this is Sandy Ells from Avon Lake, Ohio. And the question to your tweet was, should Donald Trump have a new Supreme Court justice nominated before the election? And the answer is yes. We elected him to do this, and I expect that he will. He has a duty to do this, and I think that it should happen quickly.
Well, thanks for your answer, but I wonder what you would have said about President Obama's duty to nominate and fill the vacancy of Justice Scalia. He did. He nominated Merrick Garland, and the same people who are now saying rush through this nomination, particularly Majority Leader McConnell, are saying, no, I've changed my mind, or the considerations are different, the arguments are different. We now have a president and a Senate, both controlled by the Republicans. Do those distinctions make any sense, or are we just seeing partisan politics trumping principle? That's the question. So the real question is, can you have a different rule for President Obama and Merrick Garland than for President Trump and whoever he nominates? And I think the answer, as a matter of principle, should be we should have one principle that governs. My suggestion for the future is that the Senate should not take up any nomination made after the conventions are over. That is, any nomination from late August, September, October. But that would have to be decided by a rule of the Senate. And the Senate has the power under the Constitution to establish its own rules. The one thing it shouldn't do is change the rules depending on the partisanship. Steve from Indiana, what's your question?
I'd like to ask the professor what he thinks about perhaps Trump nominating a conservative justice, perhaps a Hispanic female, a black female, or a Jewish female, and put that name forward with the promise that that will be brought up after the election and get that kind of reaction. Might call Biden's hand a little bit. Love your show, love your podcast. My name's Steve Wolland. I'm from Bloomington, Indiana. Thanks. Bye.
Hi, thanks so much for your question. What an interesting suggestion. The president may very well nominate a Latino woman. One of the people on the short list is a judge from Florida. Unlikely he's going to nominate anybody who would be acceptable to the Democrats. But the idea that he makes the nomination and then the Senate confirms after the election. Remember, a third of the Senate will be elected also on November 3rd, and we'll have a different composition. Who knows whether the Democrats or the Republicans will control the Senate at that point. Look, I wish we could go back to the days of Herbert Hoover. Who's ever praised Herbert Hoover before? I'm praising Herbert Hoover. When Oliver Wendell Holmes, the great justice, retired, Hoover was given a list of 10 names. And on the bottom of the list was Benjamin Cardozo, who was a Democrat, Jewish, somewhat liberal, all the opposite from what Hoover and the Republican Party in those days represented. And Hoover turned to his attorney general and said, it's a great list, but you have it upside down. I'm going to nominate Cardozo, even though he's a Democrat and there's already been one Jew on the Supreme Court, because I want the greatest judge in America to replace the greatest justice in America. And he nominated a Democrat, Benjamin Cardozo. That couldn't happen today, unfortunately. Oh, for the good old days. Hey, great questions and comments. Please continue to call in. I love debate, dialogue, answering questions. So give me your best shot. Call our listener line at 216-710-0050. I want to hear your questions, your comments, your criticisms, and your opinions. Remember, all calls are recorded and we reserve the right to use your questions and comments on the air. Once again, the listener line is 216-710-0050. I look forward to hearing from you. The Dershow is available on iTunes, Spotify, or wherever else you get your podcasts.